We have an interesting situation with the county that's located near Minneapolis called Hennepin County. The DA, well, the Hennepin County Attorney's Office, has got a new directive that they started this past Monday. This is 5/5, uh, so May 5th, 2025. So it was a week ago that if you are a certain or if you are certain skin colors, then they may possibly not even charge you with anything. They're going to do plea deals that are going to benefit you, not hurt you. So you commit a crime, and if you are a certain skin color, hey, things are going to go better for you. Now, the Department of Justice is going to be investigating this. They're going to try to figure out if they think that there is something unconstitutional about this and then deal with it however they want to see. So, I've got two news clips here. One news clip is the original clip talking about this from a local news program, and it's going to have three attorneys who are going to give their expert opinions. Well, okay, they're going to give their opinions. With lawyers, there is no experts because it changes from minute to minute. And the next is talking about what the Hennepin County area is talking about after it's been found out the DOJ is saying that they're going to investigate them. Okay, so let's get into that. Before that, though, do me a favor, hit like, subscribe. This subscription can help me. I'm trying to get to my first goal is to get to 500 and get my 3,000 hours in and get to the point that I can start getting some advertising and everything. But here's the videos.
Howdy, y'all. This is Paul, the Redneck Thinker. What we have here is a channel to communicate. I want you folks to be thinking by the time you leave my videos. Why? Because I'm tired of people talking via what other people tell them to think. So, watch my video and enjoy the chance to think for yourself.
Starting on Monday, prosecutors in Hennepin County are being asked to enact a very controversial policy. They will be required to consider race when offering plea deals. It's part of a new policy from Hennepin County Attorney Mary Moriarty. Lou Raguse leads off our coverage tonight. Lou?
Julie, this new policy was sent to me by sources within the Hennepin County Attorney's Office concerned that the policy could be unconstitutional if they start taking race-based government actions in their roles as prosecutors.
This is a new negotiation policy set to go in effect Monday in Hennepin County Attorney Mary Moriarty's office. In it, Moriarty lays out several considerations, including race, that our prosecutors should take when extending plea deal offers to defendants. The policy says proposed resolutions should consider the person charged as a whole person, including their racial identity and age. While those factors should not be controlling, they should be part of the overall analysis. Prosecutors should be identifying and addressing racial disparities at decision points as appropriate. KARE 11 News provided a copy of the policy received from sources in the County Attorney's Office to University of St. Thomas Law Professor Rachel Moran, former prosecutor Imran Ali, and U of M Constitutional Law Professor Jill Hasday. Ali says he understands confusion expressed privately among prosecutors about whether it means race should be considered when proposing a prison sentence.
Our law, our sentencing guidelines that we have that the criminal justice professionals use every single day in court says that race should not be used in that calculus. This seems to contradict our sentencing guidelines.
Moran believes the policy was carefully written to avoid the Equal Protection Clause of the U.S. Constitution.
I definitely think that some people will get worked up about the issue, but I don't see a constitutional problem. And that's specifically because the policy tells prosecutors to avoid racial disparities, not to create them.
Hasday reads the policy as contradictory.
It both says don't take race into account, presumably because of the constitutional problems with taking race into account in addition to potentially political objections. but it simultaneously says this is something you should consider.
And because of that, Hasday believes the policy could face constitutional issues, even if it was intentionally written to try to avoid them.
Problem for the drafters of this policy is once you take race into account, it doesn't really matter what else you say. The policy is going to be struck down.
Mary Moriarty declined an on-camera interview and didn't answer specific questions that I had regarding potential constitutional issues. In a statement, a spokesperson wrote, in part, this policy acknowledges that there are many factors to be considered in negotiations. A defendant's race matters because we know unaddressed, unconscious biases lead to racial disparities, which is an unacceptable outcome.
It is hard to look at that, though, and not think, how can that be constitutional?
Right. Well, what Jill Hasday says, the constitutional law professor, she specifies that when it comes to age, Moriarty in the policy addresses reasons why age is to be considered, and that has to do with the science behind the brain development and stuff like that. So Hasday thought that it was adequately explained for age to be constitutional, but she says the U.S. Supreme Court is so much stricter when it comes to race, and their past rulings made it clear that you can't cure societal problems with racial disparities by using race in government actions. That's the explanation from the constitutional law professor.
And the thought is that someone who is a white person, for example, will be the person to bring this case forward, and it could go, who knows, all the way to the Supreme Court.
Defense attorneys would call and say, look at this, I didn't get as good of a deal for my client as this person is getting. That's the fear that it would raise.
All right, well, we're glad you broke the story. A lot to talk about and think about there.
Absolutely.
Thank you, Lou.
We start tonight with the Department of Justice announcing that they will now investigate the Hennepin County Attorney's Office. It stems from a story KARE 11 first brought to you and broke to you about the county attorney's new policy that would require the consideration of race when it comes to plea deals. Joe McCoy has the latest for us tonight.
Well, Morgan, this new policy at the Hennepin County Attorney's Office went into effect on Monday. And now the Department of Justice says it will be investigating if the policy is illegal and deprives people of rights, privileges, or immunities protected by the Constitution and U.S. law.
The Hennepin County Attorney's Office and the U.S. Department of Justice are now in a legal battle. In a letter addressed to County Attorney Mary Moriarty, the DOJ says its investigation into the Hennepin County Attorney's Office will, quote, focus on whether the HCAO engages in the illegal consideration of race in its prosecutorial decision-making. This investigation comes after the Hennepin County Attorney's Office began a new negotiation policy Monday that requires Hennepin County prosecutors to consider a defendant's race, among other factors, when negotiating plea deal offers. One section of the policy states, quote, racial disparities harm our community, lead to distrust, and have a negative impact on community safety. Prosecutors should be identifying and addressing racial disparities at decision points as appropriate. In addition to investigating this new race-based negotiation policy, the DOJ says they will conduct a full investigation to determine if the HCAO is, quote, engaged in a pattern or practice of depriving persons of rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. In a statement to KARE 11, the HCAO says they will cooperate with any resulting investigation and are fully confident their policy complies with the law.
The Hennepin County Attorney's Office says the goal of this policy is to achieve safe, equitable, and just outcomes that center the healing of victims while improving public safety.
So, you heard all that. A whole lot of information dumped right there. What do you think? Do you think that this is unconstitutional? Now, honestly, the way that I have paid attention to the law and talking with lawyers on the situation, I honestly think that Mary Moriarty has done something that is unconstitutional. I think in the broad scheme of it, yes, it is unconstitutional. As one of the lawyers said, it brings up race. This thing is called Negotiations Policy for Cases Involving Adult Defendants. So, racial identity, that really, you're crossing into an area that you're going to have way too many problems. Especially now that you've done this during the Trump administration, because they're going to take a look at it. They've already been attacking DEI. They've already been going after all of these idiot things that are supposed to elevate one race over another. And that's what DEI and CRT and all that does. So, I mean, then again, though, I mean, at the same time, before all that, like in my youth and well before then, actually in my youth that was going away, but in the 50s and 60s and before then, there happened to be some race-based considerations back then too, and that was bad. So yeah, any race-based considerations is bad. This has been Paul, the Redneck Thinker. Y'all give me your opinion on this. Bye now. So folks, that's the story that I wanted to bring you on this video. And I just wanted to say thank you again for coming by. Hit like, subscribe, comment, all that fun stuff if you don't mind. Help me out. So, y'all have a good day now. Bye.